Hi everyone, my name is Elina Gilbert. I'm with the Transactional Department here at Heinemann Sanchez, and today I am going to talk to you about everyone's favorite subject, water leaks. They happen fairly often, and yet it always seems that when someone does have a water leak, everyone freaks out and doesn't know what to do about it. So the purpose of this little video is to give you a quick step-by-step guide as to the thought process and analysis that you should perform when there is a water leak in the community. So of course, a lot of this is going to depend on the governing documents and what they say and who has the responsibility for which portion of the community. But generally, when there is a water leak, the first question that everyone should ask is, where did it originate? What's leaking? Is it a pipe? If it's a pipe, which portion of the pipe is leaking? Where is it located? Is it in the wall? Is it under the sink? Is it in the basement? Where is the leak? What unit is it in? The other question that you should ask is, who has to specifically maintain this particular component that has caused or that is leaking? If it's a roof, for example, and you're in a condominium community, most of the time the roof is going to be the responsibility of the association. Townhomes typically also might be with the association. However, if it's a water pipe, again, that's going to depend on where it's located. Is it a common area pipe? Is it part of the unit? And that's an analysis that has to be performed. So the key here is we don't really want to look at whether there was any negligence or whether someone willfully did something. We just really want to know where the leak started, and regardless of anything else, that component, who is going to be or who is responsible per the documents to maintain it and repair it. Next, you have to look at what was actually damaged from the leak. Obviously, the component that caused the leak is also damaged, or else it wouldn't be leaking. But where did the water go, and what has it damaged? Did it go inside a unit? Did it damage drywall? Did it damage fixtures? Did it damage personal property? You need to look at all of that. And then you need to compile that information and again figure out for each damaged component under the declaration who is responsible for its maintenance and repair. Again, this is really hard to do, but do not look at whether anyone was negligent yet or whether somebody willfully caused it. It doesn't make a difference for the purposes of this portion of the analysis. So once you kind of have your neat little chart of here's the component that caused the damage, here's who repairs it and maintains it, here are the components that were damaged as a result, and here's the person or association, here's who has to repair and maintain those. Now you want to look at a couple other things. All these components that we just listed as either causing the leak or being damaged, who has to insure those components? It's very important because a lot of times leaks are covered through your property policy, and to the extent that there is coverage, especially if it's the association's insurance that insures it, there is a duty on the part of the association to submit a claim. Here's where a lot of the hang-up is when it comes to submitting claims. Many associations believe that if the water came in through a component that is maintained by the association or that was negligently maintained by a homeowner. So for example, if you have a pipe that burst and the board is convinced that the owner did not properly maintain that pipe and that's why it burst, those boards have a very hard time submitting a claim to insurance because they believe that if the homeowner caused it through their negligence, then why should we submit it to our insurance carrier? That's a completely inaccurate way to look at it. The key is insurance under Colorado law that the HOA purchases is not viewed as the association's insurance, it's viewed as the homeowner's insurance because they pay for it. Therefore, to the extent that there is a claim, regardless of whether it was caused by a homeowner's negligent or willful action, the association has a duty to submit that claim to the insurance carrier for coverage. If the association does not submit the claim, then it is responsible to pay out of pocket any amount that insurance would have covered. That brings me to my next point, which is you need to try and figure out what the total damages are. It doesn't have to be an exact dollar amount, but try to get a ballpark to see if the total damages exceed the association's insurance deductible amount. If damages do not exceed the deductible, you have a $10,000 deductible, and we know there's only $5,000 to $6,000 in damages. Obviously, there is not a requirement that a claim be submitted at that point because it wouldn't be covered anyways under the deductible. However, if the damages exceed the deductible, you should be submitting a claim. Finally, make sure that whatever you do, you document it. You document the research the association has done. You document what the components are, and you document any expert opinions you receive upon which you base your opinion. Obviously, this is a quick tutorial. There's a lot of analysis that goes into that. But if you have questions or want to discuss this further, please go to our website. You can see the address below, and you can submit questions or look up any of our articles that have lots of information on this. Thank you.